We good, Marion? All right, committee members need to leave, can leave a proxy. The committee will stand at ease. All right, committee will come to order. We'll get started with Delegate Watts. You're up. You can tell us your bill number real quick.
Yes, I do. It's House Bill 2499.
Committee will bring your attention to 2499. Let me get to it here. Go ahead, ma'am. The floor is yours.
Thank you very much, Mr. Chairman. 2499 language directs the Department of Corrections to develop policies to improve the exchange of medical and mental health information, particularly through telecommunication. This is a follow-up on a report of last year about how we might do more in telemedicine. Thus far, the first focus has been on the Appalachian telemental health initiative, and this then provides another very important linkage of sharing information between administration of any prison as far as security issues and safety issues, all the way to rehabilitative issues, and you might also have private sector providers also as part of that linkage. And particularly given HIPAA, it's important that these things be carefully spelled out so that everybody's confident about what can be shared and should be shared on a need-to-know basis, but through telemental medicine, it can be done in a timely way.
Mr. Chairman.
Senator Black.
Quick question. You know, I'm aware the inmates are frequently moved from prison to prison. I mean, it's not uncommon that they're there 3 months, they're somewhere else 3 months. And is it the experience that medical records have taken a long time to follow them under the present system?
Yes, Senator Black, that would definitely be the case. And again, now that we have mental medicine, it's going to expedite the important following of those records, particularly for individuals who, again, maybe either safety or have real therapeutic issues that need to be addressed.
That certainly makes good sense. Thank you.
Any other members have a question for the delegate? Anybody wish to speak for the bill or against the bill? We'll take fours first. Bueller, anyone? Bueller.
Move the report.
It's been moved and properly seconded that the bill be reported. Committee will vote.
Mr. Chairman,
Let's strike the board.
thank you.
My lady is. Oh,
Let's be ready to go. Committee ready to vote. I thought he gave us one. 14-0. Thank you, Delegate.
Thank you very much.
Apparently Virginia Beach is at the beach today.
Just dreaming of home.
All right, next on the queue, Delegate Knight.
Yes, sir. I've got House Bill 1770. I think it's got a fine patron in the Senate for a very similar bill. This is the distillery bill, which on my side has been amended to 12% commission from the 8% commission, and to allow certain ABC stores to open at 10 a.m. And the 10 a.m. ABC stores, there's about 375 in the state. This would look at about 250, and they would only be allowed to be opened for the same localities where beer and wine is sold at 10 a.m. or before.
Hey, Chapin, put Chapin's down to me because you hit the. Thank you, committee members. This is the. What?
We voted this out.
This is the same one that I carried. It came out of here 12-2, and the big difference is the two line amendments. And Delegate Knight, you have any problem with conforming yours to mine, and then we hash it out?
That'd be fine.
All right, it's been moved and properly seconded to conform House Bill 1770 to be the same as 1668. All those in favor say aye.
Aye.
Any opposed? Okay. All right, it's been moved and properly seconded to report the bill. Committee will vote.
Nays 12, nays 2.
Thank you, sir.
Thank you, Mr. Chairman.
Delegate Landis behind there? Oh, you're over there. Delegate Landis.
Thank you, Mr. Chairman, members of the committee. Mr. Chairman, I have House Bill 1657. And I don't think you've seen this one before unless Senator Hanger had one.
No.
Or Senator Openchain. But this is basically would create an annual mixed beverage performing arts facility license that allows the sale of alcoholic beverages for on-premises consumption at any multipurpose theater that is located in the historic district of the town of Bridgewater, that is owned and operated by the town and has a total capacity of more than 100 patrons. This came as a request of the town of Bridgewater, who is building a theater and multipurpose facility. And actually, even though they're not going to serve alcoholic beverages during their meetings, actually the town council is going to be meeting in this facility as well. So, Mr. Chairman, that's basically what it is. It just adds to the Christmas tree of other like permissive licenses.
So, Delegate Landis, I'll just tell you, and for the other House patrons here, this committee on the Senate side is requesting of ABC to do a study of all the exceptions to the licenses procedure and come up with a big summary for us to kind of consolidate these things and allow these different types of exceptions that we're calling out all the time to come under a different umbrella so we can consolidate and do that. And we've let a few of those exceptions go out this year with the caveat that it'll probably wind up going into that study that we have ABC doing. So does anybody have a question for the patron of the bill?
Mr. Chairman,
Yes, sir.
well, on this particular bill, then this one that we can't let out,
Can we let it out?
yeah.
I think we're fine. I carried this bill a couple of years ago as well for the facility here. And we've let two of our own members have two exception bills. I think Senator McPike had one and Senator Sturdivant had one that we let out.
Well, reading this, I don't see no problem. I could hope we can let this one out.
Okay. All right. Any other members have a question? Looks like you have Mr. List, but I think you're in good shape right now. All right. I have a motion to support.
He's consistent.
All right. All right. I think you maybe have somebody that doesn't want to have this bill. Come on up, Mr. List.
Yeah, thank you, Mr. Chairman. Tom Lisk, representing the Virginia Restaurant Lodging and Travel Association. We appreciate what Delegate Landis and the town of Bridgewater are trying to do, but it is another carve-out for an establishment that does not have food but would have alcohol. For that reason, we oppose it.
Got you. Thank you, Tom. Travis, you taking notice, right? Got it. All right. It's been moved and properly seconded to report the bill. Committee will vote.
Nays 13, nays 2.
13-2. Thank you, Delegate Landis.
Thank you, Mr. Chairman.
Delegate Peace.
I know, I know.
Is Delegate Peace here?
And Mr. Chairman, Delegate Peace has the Family First legislation that we heard previously in this committee.
Okay.
If
me
you'd
get
like
to
me
it.
to speak to that, sir?
Give me the bill number,
There
Monty.
is one difference, 12.
Right there,
Oh,
David, you
got
get
it.
that?
2014.
David, do you want to tell us what the difference is?
Yeah.
Mr. Chair, the differences are basically technical. If you look on your handout there, there's a couple of line amendments, one on line 740, the other on line 633. This is just a technical cleanup to put the language in line with one another. The only thing that is different that we will need to leave different is the final enactment, which is an emergency clause, which needs to be different because basically Delegate Peace's bill is a combination of two bills that Senator Mason carried, and for that reason, the emergency clause needed to be worded a little bit differently, but in essence does the exact same thing.
Gotcha.
Second,
We don't want to conform, we want to change.
two minutes.
Yeah, so we have the amendments before us. It's been moved and properly seconded to accept the amendments. All those in favor say aye.
Aye.
Any opposed? Okay, now we want to report the bill, right, David?
Yes.
Yeah, okay. So, been moved and properly seconded to report House Bill 2014, all committee will vote.
Yeas 15, nays 0.
15-0, okay. Delegate Toscano, you're up.
Good morning, Mr. Chairman. I have HB 1960.
I do have to tell the committee, if this report's out, Senator Hanger, Senator Norman need to see it in finance. It is a revenue bill, so. Go ahead, sir.
Okay.
Hanger's right there.
He cares.
So thank you. Mr. Chairman, members of the committee, by no means am I an expert on ABC law, but so far as I can understand the law now, right now, other states permit the manufacturer of what are called low alcohol beverage coolers. These are things that are under 7.5% alcohol. And then those coolers can be sold in Virginia and are sold in Virginia. Right now, Virginia is at a disadvantage because we don't allow the manufacturing of these. What this bill does is changes that so that distillers can manufacture this in Virginia. They can be sold in Virginia. And I think that'll help some of our business entrepreneurs who are trying to start new businesses. And I do have one with me who is prepared to speak to the bill.
Super. Let's hear from him.
Yes, I'm here to support the bill.
And you are?
I'm Wilson Craig
And who do you work for?
from Charlottesville, Virginia. We're hopefully starting a distillery with the idea that we could produce these beverages in the Commonwealth of Virginia. Currently, they're produced in North Carolina, Pennsylvania, and neighboring states. And we ask that this bill be passed so that it puts us on a level playing field with producers in other states. Currently, multiple other states produce these cutwater spirits in California and several other producers in North Carolina, Pennsylvania, et cetera.
And Mr. Chair, if I might just
Yeah.
amplify that. We work with the ABC to make sure we had all the Ts crossed and the Is dotted.
Okay,
And I don't think they have any issue with the bill.
okay.
Mr. Chairman.
Why don't you do that? All right,
Mr. Chairman.
Senator Cosgrove.
Delegate Toscano, can you give us an example of what a low alcohol beverage is? Are we talking like something like a wine cooler or what Bartles and James?
My expert here would be in a better position to make.
Yes, sir. So a good example is a 12-ounce drink, a canned beverage with lower than 7.5% alcohol by volume. So, for instance, like a vodka soda with less than 7.5% alcohol by volume. So it's canned. It could be a vodka soda, a Moscow Mule, a Bloody Mary, et cetera.
The Moscow Mule come in a copper can? I'm only kidding.
It does not at this time.
I'm good, thank you.
All right. Senator DeStefano.
I had a quick question for the patron. And in here, it talks about maybe manufactured by a licensed distiller or a distiller located outside of the Commonwealth. Kind of what's the intent of outside of the Commonwealth? If they're doing it outside of the Commonwealth now, why are we adding it outside of the Commonwealth here?
I think that's, if I'm not mistaken, Senator, that's already the law, and I think that's what, it's just tracked in the bill that way.
David, you
David
want
has
to?
it.
Mr. Chair, Senator DeStefano, he is correct. Basically, under current law, if you are an out-of-state distiller, you can manufacture these low alcoholic beverage coolers, and they are being sold in the Commonwealth, but because of some technical language in the code, licensed distillers in Virginia cannot manufacture these drinks. So what it does is it gives that privilege, and the language about an out-of-state distiller is just to maintain what is otherwise current law, and then it goes on to allow the distiller to sell these beverages at a government store established on the licensed premises and use these drinks in their sampling as well.
So, Mr. Chairman, if I understand this right, then this creates a level playing field so we can sell stuff manufactured inside Virginia and outside Virginia, correct?
That's the intention of the bill, and David can comment on that if he wants. But
With that, I'd like to move to report.
Mr. Chairman, I have
One second. Travis, or ABC, John? All right, are you guys good with this?
Yes, sir, Mr. Chairman, John Daniel, Virginia ABC. We worked closely with the delegate on the other side in order to put the bill in a posture where we would be able to manage it.
Okay.
Mr. Chairman.
Super.
A
Senator Black.
question, if I could. Is there really a difference between the coolers and just a pre-mixed drink? I know there are certain things where you can buy a bottle and it's basically a pre-mixed alcoholic drink. Is there a difference really between the two of these?
Well, the difference is, of course, the alcohol by volume. I mean, and it's simply a numeric calculation of 7.5 greater or 7.5 less. And we've characterized those beverages with less than 7.5% of alcohol by volume as coolers, and they're taxed differently than spirits.
Right. So we got a motion to report and refer to finance. It's been properly seconded. Let me ask you, is there anybody opposed to the bill? I sometimes forget to ask about that. If you're in opposition to any bill, make sure you stand up so I can see you, because we got a heavy docket, and I probably only have one in a subcommittee left. So, all right, I see no opposition. It's been moved and properly seconded. Without further discussion, let's vote.
thank you very much.
Thank you, Delegate Toscano. Delegate Bell. I'm sorry, Mr. Chairman. I would have got you up here quicker, knowing that you got
Actually, I got nothing this morning.
reviews
Thank you.
today.
All right, Mr. Chair, members of the panel, and Senator Boysko.
1942?
House Bill 1942. Yes, sir.
Okay.
So, Mr. Chairman, members of the panel, this is a product of the Deeds Commission, and this is one we've been working on actually for a couple of years. The issue is delivery of mental health care in jails. And while it had been on our radar, it was expedited, especially prompted and made more important by the death of Jermichael Mitchell at the Hampton Roads Regional Jail. And our conclusion after the years of study is that we will do everything we can to find ways to divert people out of the jails when they're mentally ill, but realistically, all of us will be long gone and there will still be a large number of mentally ill people in jails, and they cycle in and out. And so the goals are threefold. The first would be there are, in fact, no mental health standards for jails in Virginia. And everybody's just eyes pop out of their heads when you say that. There are constitutional provisions, there's case law, but the Board of Corrections has never actually established a list of things that every jail has to do. And so this would, most of us had never heard of the Board of Corrections until a couple of years ago. The board is the board that manages jail provisions. This would say the board has to develop standards in consultation with all the other agencies that have parts of that. The second is there are concerns about this cycling. How do you get someone whose jail is for short sentences, 30, 60, 90 days? People are receiving mental health care in the community. They go to jail, an entirely different provider does or doesn't provide care, and then they can't share those records with the community care.
Go ahead, sir.
Oh, I'm sorry. And so the goal is to try to get around HIPAA issues so that the CSB can say he likes lithium, not Risperdal, or this is his issue, or here's his favorite provider, all those things to help the jail be more successful. And then transitioning out, there's a term of art that you can see called discharge planning. And it sounds like it's on the last day of jail. It's actually for the whole day, the whole stay. But the goal would be when you're there, sometimes you actually get better. You get stabilized, the meds, you get the bad drugs out, you get the good drugs in. When they hand you back to the CSB, we want to put you in a better place at the CSB side. Mr. Chairman, that's what the bill does. There are 2 enactment clauses. The first would be that they will have until 2020 to put all this in place. This has obviously got a lot of moving parts in a lot of jails. And the second is, while there are some state costs, the primary costs for this are going to be at the local level. You'll see a paragraph that talks about how they want to convene stakeholders just to talk about it. Sort of how the costs are going to be between the sheriffs and the jails and the localities. At this point, with all of that, it appears to have no opposition, but I would be happy to stand aside and let someone tell me they've now changed their mind.
Senator Cosgrove.
Yes, sir.
Thank you. Actually, not a question for the patron, but a statement. I have been on that mental health working group for the last, 4 years now, Rob?
I think so, yeah.
Yeah. Delegate Bell has put a lot of work into this. He chairs the particular subcommittee for that working group. This is a serious problem that we have in Virginia. We've seen that numerous times in our correctional facilities, and I really hope that it would be a unanimous choice of this panel to report this bill.
Senator Black, did you have a? Okay.
A question?
Senator Sproul, then Senator Favolo.
Mr. Chairman, question to the patron.
Yes, sir. Yes, sir.
Knowing how the board, I guess, made political appointees, I want to make sure that this is great. But do we have people on the board that can make sure these records and stuff is kept quiet, put in its proper place? I'm trying to find qualified people to do the job.
That's a great question. So when we started, the Board of Corrections was seen as a board that I'd never heard of it. After 16 years here, I didn't know that jails had their own board. The appointees of the board, and I don't know if
Time about that.
They've changed a lot already. Is what the governor went through and said, this is not going to be a board where we get together every so often and get pizza. This is going to be a very important board. They've rearranged the people on the board, and in the House, they said they were going to actually bring in people that are really good at designing regs. Yes. I don't know if that's. I mean, that was the board. What the board said they would do.
Thank you.
Yes, sir.
Delegate Bell.
Yes, sir.
Would you mind if, because this committee handles DOC,
right.
Would you mind if that report at the end of this thing, David will tell me the correct line again, that it be reported to the Committee on Social Service, the Senate Standing Committee on Social Service and Rehabilitation?
Of course not.
Is that okay for a friendly amendment? I'd like to make that amendment.
Sure.
If I can get a second.
A second.
All right, it's been probably moved and seconded to add the Standing Committee on Social Service and Rehabilitation. David, can you tell us where it'll be? And
Mr. Chair, the amendment would be on line 168 after health, insert, comma, and the Senate Committee on Rehabilitation and Social Services. And with that, we would strike the "and" on line 167.
All right, it's been moved and properly seconded to add that. All those in favor say aye.
Aye.
Any opposed? All right, Senator Favolo.
Mr. Chairman, quick, I guess a couple questions. Is there money in the budget for this?
So the costs are local. So in terms of the jails, this is not a DOC, it's a BOC.
It would be completely.
On the House side, they did send it upstairs. And so
Yeah.
I don't know if you must send it upstairs or not. I would obviously rather not, but if you got to it. I was kind of looking for staff or Senator Hanger to tell me if it's going upstairs.
You need it
Mr.
upstairs?
He does have a delayed effective date on actually the costs that will incur into the next budget, but it wouldn't hurt to just routinely pass through there. It won't be there long.
Because there is a state match for sometimes.
Right, and I would say that
it's good.
Mr. Chairman, I guess one quick follow-up question.
Yeah, go ahead.
At some point, we would aim to have this policy apply to any inmate in either local, regional, or state facility. Would that ultimately be the goal?
Yes, well, sure, except DOC has its policies already. This is not for prison, but it would be for all jails. So whether it be the smallest sheriff-run local jail in Page County or the big regional jails, where you are, I think Arlington.
Yeah,
But
we're in a-
Fairfax, of course, are very
yeah,
sizable jails.
We're in a local.
Okay.
So this policy mirrors what's already in place at the state.
I wouldn't say
Facility.
that. BOC is going to be coming up with their own regs, and of course, they've got a different set of regs. If this,
Okay.
this is not for the prisons.
No,
That's-
I
Senator
understand.
Favola,
Thank you, Mr.
I'm going to
Chairman.
remind you of your manners to go through the chair, please.
Oh, thank you, Mr. Chairman.
Not a running dialogue.
Okay. So, Mr. Chairman, I think my final question is, I really like this, so at some point, I guess I would be looking for conformity with all of our policies, regardless of the level. That's not going to stop me from voting for this. And I understand there may be work needed for the state facilities. So-
Got it. Senator Serval, come on back to you.
Doug Bell.
Yes, sir.
You know, I have to request my clients' medical records sometimes when I'm defending them because I want to see what's going on and I need it, or somebody on the outside wants to see it. The way that I was looking at the language, and I haven't thought about what the interplay between this and HIPAA is. And the way the statute seems to be written doesn't authorize disclosure to the subject of the records themselves. And I was curious whether you or counsel knew whether HIPAA trumps this, or whether we're allowed to adopt something that's more restrictive of information escaping than HIPAA is. I just wanted to make sure we're not cutting off somebody's access to their own records.
This was not about that issue. If that's something that we could fix as part of this, I wouldn't mind. But the inmate's access to his own records was not the issue. The issue was the HIPAA. I'm no HIPAA expert. This was something we looked at a lot. They said that the language will make it much easier for the CSB that has a 6-inch file on the person that they see once a week to provide the information necessary to the jail who doesn't have any file, or maybe they only have a file from the last time, or maybe he was in Arlington one time and Fairfax and the other, to just try to get the right mental health records to the jail to get the mental health care that he needs. And then at the back end to say to the CSB, hey, we tried whatever, we tried Amplify, Risperdal, lithium. After 60 days, the lithium kicked in and it was great. To give that to the CSB so they could say, all right, Mr. Serval, we see that you're doing better in jail on lithium, let's try that. They say this will do it. Now, again, I have no, HIPAA is a federal law in the medical health care realm, neither of which I know much about.
Mr. Chairman, further question?
Okay, hold on. I got Senator Cosgrove, and then I got, did you have a follow-up question?
Yeah.
Oh, go ahead.
Said further question. If you could get an answer to that before it hits the floor, that'd be helpful. My guess is probably this does not limit patient access to their own records, because it doesn't look to me like you're deleting any language, and I know what current practice is to release patients' records to themselves under HIPAA, but
I'll look that up. I'll find out.
I'm sure somebody around here can figure that out for you. The second question is, I just want to make sure that another way that we hold local jails or correctional facilities accountable on these things is if there are policies and procedures that could be obtained by FOIA, not necessarily people's records, but the policies and procedures themselves. And the way this is written, it's not clear to me, 100% clear to me that that's still the case. I mean, is it, just so I'm clear, is it your intent that the policies and procedures also stay confidential, or that only the person's records and that's it?
The latter. I wouldn't want any policies or procedures to be confidential. Now, as you say, the actual inmate's mental health records, we would have the same protection. It's just outside the. Okay.
Okay, thank you.
Yes, sir.
All right, Senator Cosgrove, then Senator Boysko.
I'll defer to Senator Boyce.
Senator Boysko.
I just wanted to point out, there was another bill that I sponsored, actually, that would allow our CSBs to putting together a work group to deal with how that information is shared, that I think would be probably hand in hand with this legislation that could be helpful in solving some of these questions that people are coming up with today. Thank you.
Okay.
Mr. Chairman.
Senator Cosgrove.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. Delegate Bell and the people that were on the working group have worked very hard on this. They have talked to an awful lot of people. We have visited mental health facilities throughout the Commonwealth for the last 4 years. We've met with almost every expert imaginable on this, and Delegate Bell has been at every single one of those meetings. This bill is well crafted. It's and I really hope we don't use this as just a springboard to do a bunch of other things. This is something that needs to be happening now. And with that being said, Mr. Chairman, if you'll allow me, I would move to report as amended and then refer to finance.
Second.
Okay. It's been moved and seconded to report the bill to finance. Committee will vote. All that talking for a full flush.
Mr. Chairman,
Thank
thank
you.
you. Mr. Revelle, I will get that for you.
Delegate Hope.
Thank you, Mr. Chairman. I've got, I think, a few bills for you. You want to take 1642, solitary confinement bill. Senator Saslaw passed a version out. We could conform that if you'd like. 1642, Mr. Chairman.
All right, David, do you want to go through some of those?
Mr. Chair, there would be a total of 7 line amendments we would likely do as a substitute. Most of these are technical. I can roll through each one if you would like. It is on your handout listed at the top.
Okay.
The
You
only-
don't need to. Let me hold you up because we're running tight on time again already. Any members have a question? It's on the handout, the first block that you have in front of you. Everybody okay with the amendments? And then we'll conform it. Do I have a motion on the amendments?
So moved.
It's been
Second.
moved and probably seconded to accept the amendments. All those in favor say aye.
Aye.
Okay, and a motion to conform to Senator Saslaw's bill? It's been moved and probably seconded to conform. All those in favor say aye.
Aye.
And
Move report.
it's been moved and probably seconded to report the bill. All those in favor will vote on the board. Fourteen-one. You got another bill?
Yes, sir, Mr. Chairman. 1815.
Okay, 1815.
This bill it's more of a simple bill. You probably saw a similar version from Senator Howe. They do different things, and so I just want to point that out, so you can't conform the two. But this one is a joint commission on health care. Oh, I'm sorry, you do have a
We do.
substitute.
Yeah.
I'll just do that first. Let me do that first.
Been moved and probably seconded to accept the substitute. All those in favor say aye. Any opposed? All right, that's before us.
What the substitute does is when we passed out of the House, we noticed that it was in the wrong section, and so we put it in the appropriate section too. We're also making very clear what this does is that we're making sure that assisted living facilities do have generators. If you don't have a generator, or even if you do, whenever your prospective resident goes to the assisted living facility, they'll have to disclose whether they do or they don't. And this language just says that it's a joint commission on healthcare recommendation.
Okay. David, do you want to just talk a little bit about the subtle differences? If we report his bill out, what the difference will be, and maybe they'll have to work it out.
Mr. Chair, so Delegate Hope's bill is somewhat similar as far as the subject matter goes to Senate Bill 1077, which Senator Howe carried. And basically, under the terms of Senator Howe's bill, there would be certain information about on-site generators that would require to be included in the emergency preparedness and response plan of the assisted living facility, while under Delegate Hope's bill, it pertains to information that would actually have to be disclosed directly to the resident or the resident's legal representative in writing and acknowledged about their capabilities regarding on-site generators.
Yeah, at the time that they go, at their perspective.
So when they first get there, they've got to have it in a disclosure brochure.
Yes, sir.
That's the goal, and hers just says that we have to have a plan, so. All right, anybody wish to speak to the bill in the audience? We've heard this bill before, minus those changes, so. Senator McDougal?
Mr. Chairman, so we've adopted a policy of doing it one way, and this is the same information a different way. I think we should go with the policy the Senate already adopted and then let them work it out through the process. Unless Senator Mason has a different thought.
Mr. Chairman, I happened to see this debate yesterday on the other side, and they are a little different. I mean, they're taking two different, yours is notifying the patient and its representatives. The other is notifying the public what is available, and, oh, by the way, if it's available, it has to be tested and it has to be worked through, and you have to make sure. So they really are different, I believe, sir.
Yeah, we discussed this in the House side, not that they're the final decision maker, but we decided to do them separately for that reason, because my bill is a negotiation or contract with the resident. Senator Howe's bill is a contract or an agreement with some other entity to make sure that they have a
this stuff in place, the contracts in place for generation. It's just completely
I get
different.
it. It looks like you got a line of people behind you. So, Tara, do you want to speak?
Good morning, Mr. Chairman. Tara Ragland, licensing DSS. The administration supports this bill.
Okay. Tara, what are you going to do if you got two bills? How are you going to fix it to make it?
Ooh, we were talking about that yesterday. There's a couple little inconsistencies, but I think we can work it out. But one's more of a disclosure, right? And we already have a disclosure, so we can work this one right into what we already have. The other one is a call to action, basically, for the facilities to actually have something in place.
Okay.
Morning, Mr. Chairman.
Morning.
Scott Johnson for the Virginia Healthcare Association. We've worked with both Senator Howell and Delegate Hope on this, and we ask for your support of this bill.
Okay.
Mr. Chairman, Carter Harrison from the Alzheimer's Association. We also support the bill. The two policies are really, they cover the same area, but they're two separate pieces, and they can exist separate of each other, so.
Okay. Thank you.
Mr. Chairman?
Senator McDougal? And then I'll go to.
We heard the administration said there are inconsistencies. David, are there any, with the substitute, are there any inconsistencies between the two? Because I'd rather us figure those out instead of relying on y'all to figure those out.
It's minor. I believe this one says that there's 6 or more, and our regulations basically say that you are licensed at 5. I mean, more than 4 or more. Got that wrong yesterday, but 4 or more. So that was about the only inconsistency we wanted to work out, is just to be able to have a consistent number with both bills.
What's the regulation?
Yeah.
All right. David?
Mr. Chair, if we could get the representative from DSS to maybe point to the line number of which they're talking about for the number. I'm unaware of the 6 versus 4.
4 or more. Is the reg 4 or more?
The reg's 4 or more, and I think your bill said 5 or 6, right? Or was that?
6.
Yeah.
Tara, 4 or more what? I guess is the question. Residents.
Mr. Chairman, Carter Harrison from the Alzheimer's Association. I might be able to help. The section where the 6 number comes from is in 63.2732. So it's not in this bill anymore. So that's where the 6 number comes from that's where the requirement for the.
No, it's not there. You're correct.
You good?
That's why getting ahead of time helps.
Senator McPike, did you have a question?
I think if that's resolved, it's fine. The other suggestion, Mr. Chairman, would be to reference the code section to Senator Howell's bill in terms of the notice of procedures if it's relevant, but I don't think it causes harm either way. I think these are complementary bills as they stand.
Okay. Any other members?
Mr. Chairman.
Servo.
Speaking of the bill.
Yep.
It just seems one solution to me might be to put some kind of amendment on it, put them both in conference, tease it out, and then bring them both back to us, conformed, fixed, whatever, but instead of doing it this way, but it's just an idea.
Yeah, I just want to make sure there's no germaneness issue with doing that. The House germaneness rules are different than the Senate. That's all I'm concerned with that. So my preference would be just to go separately.
Okay. All right. We've spent enough time on this one. All right. It's been moved and seconded to report the bill. The committee will vote. 15-0. Is that all you got?
I do have 1933, Mr. Chairman.
Let me see what that is.
I'm probably making everyone behind me angry. Mr. Chairman, this is a bill that you've seen before. It passed the House and the Senate last session, but the Senate put up an amendment on there regarding standards for jails for mental health treatment, and so it didn't make it through conference. But the policy that was supported is back here. It gives permission to jails to petition the court to authorize a treatment in the jail for an individual that's not capable of giving consent to such treatment, so that they have the ability to treat people in the jail, that they may do so, but they have to petition the court to do that.
So, Delegate Hope, that's what's changed from last year to this year?
Well, no, it's the same bill that you saw last year. The difference is that the Senate added an amendment which I believe was Senator Donovan's amendment, about standards in jails for mental health.
Okay.
And that's where we couldn't reach agreement in conference over that amendment. But the policy had been supported in the past, and so
I think maybe Delegate Bill might handle some of that. Senator Black.
I have a question. Presently, if you have an inmate who is in some sort of medical distress, what is the process? Don't you just take care of it?
No, if they're incapable of giving consent, you got to find a hospital for them. So you have to go through a process to find a bed, locate a bed. And that's also the reason why we're bringing this, is because that can be, as you know, we have a shortage of psychiatric beds. And so if the jail has the ability and the capability to provide the care there, then they would just do it there.
And follow up if I could.
Senator Black.
So today, okay, let's talk about a mental issue where the individual is in some sort of extraordinary distress. What do you do presently? Because what you're doing is you're adding a requirement to go through a court, as I understand it.
That's right. If they're, Mr. Chairman.
So what I'm looking for is what do we do today?
Well, what we do today is that if they're incapable of giving their consent, and you would still petition a court to do that, but the question is what happens to the inmate after that? What currently happens is you have to go find a psychiatric bed at a private hospital or one of our state institutions. And that can be very difficult to find beds and locate them there. This just allows for the jail, if they have the capability to provide that same treatment, they can do it right there in the jail.
I see. Okay, thank you.
I can't find it. Maybe, David, you can help me with it. There's a shallow RMA in there, and I'm trying to find it on this capability because I'm wondering if we're putting an undue burden on our jails when they're not really set up to handle psychiatric needs. Sheriff's Association and all those folks are good with it?
Yeah, they're supportive.
Okay. Hold on, Sir Sproul. Sir Sproul.
I think you're looking at right here. Paragraph C. Oops. Paragraph C. Shall describe.
Go ahead, Lon.
With the problem that we have in the jails now with the health problem, and that the jails do not have necessary staff that are qualified to handle the problem. So that's my concern with this bill, that you may call someone outside, but how can they handle the problem inside if we are having complaints right now that they don't have the capable staff inside to handle the problems?
Yeah, Mr. Chairman, Senator Sproul, that's a great point. If they don't have the capability to do this, they don't provide this treatment, and they would go through the ordinary process now where they would try to find a psychiatric bed at another facility.
Thank you.
Senator Searle.
Question for the patron. Question for the patron.
Go ahead, Senator Searle.
Delegate Hope, one of the things that concerns me about this is on pages, or lines 118, 119, 120, this purports to give, I guess, the sheriff's office immunity, absent gross negligence or willful misconduct. And while I know everybody's always worried about getting sued, I'm not clear why in this scenario, with the availability of insurance, the sign-off of a magistrate, all these other things they have to go through in order to do this, why they feel it's also necessary for them to have heightened immunity from being sued in a situation like this. And every time I see liability, it freaks me out, because that's what insurance is for.
Mr. Chairman, Senator Servo, this part of the language, a big part of this language was lifted from the code. So in other circumstances when the jail is providing treatment, so this is consistent with other parts of the code. I might ask counsel to tell me where that might be, where we have this, where the jails, because the jails do provide treatment for those that are capable of giving their consent. And so this is lifted from that part of the statute. You know, that's consistent with what we do in that circumstances, and so it's consistent here. If there's some heartburn there, I don't know if the jails would say about taking that out, but it's consistent with policy that we have in these circumstances.
Mr. Chairman, further questions?
Yes.
Dave May, is that accurate that this is the exact same standard that's in the code for other types of medical care? Because I know of all kinds of cases where jails and prisons have been sued for either giving wrong medical care or bad medical care or.
Mr. Chair, Senator Serval, I can't say for sure if it is in line. I think there's a threshold standard for services, and then some localities go above and beyond that and change. So it depends on what facility you're at, what the exact standard's going to be. I don't know the exact code section that this was pulled from and have not done a word-for-word comparison, but could definitely do that at the pleasure of the committee.
My co-counsel said it's for lack of consent. Can you say that again, Scott? Come on up here. My co-counsel, Scott Johnson.
Mr. Chairman, if you read the immunity the way it's worded, it's only immunity for having lack of consent. So if you, as a healthcare provider or a mental health provider, rely on the consent of the court, you're given immunity. If you screw up and commit malpractice, you still can be sued.
Okay, don't go anywhere, Mr. Johnson. So I got a question up here from one of my colleagues about the Donovan Amendment, and those of us serving Senate trust Savon very well with regard to medical matters. Is that in here at all?
Mr. Chairman, I wasn't in the room when that came up, and I cannot remember that. So
Mr. Chairman, I could speak to that.
Senator Hanger.
Thank you, Mr. Chairman, Member of the Senate. Last year, Senator Donovan was trying to go further. She was actually in the direction that Delegate Bell is going with his legislation, and she had a bill that was not going to advance, so she embedded the goals of that bill on this, and that's caused this to stop. So the bill by itself, I think, is in good shape.
Okay.
She was trying to accomplish a different purpose.
Gotcha.
Mr. Chairman,
Thank you, Senator Hagan.
Senator McDougal.
Maybe Scott, you could come back, because this is, we're looking in that, between lines 70 and 83, we talk about deliver or send a certified copy. Shouldn't we talk about serving the person with the copy? I mean, how do you send a certified copy to somebody who's incarcerated? Shouldn't they serve a?
Yeah, that's more of a sheriff question. I'm sorry, I just don't know that. You got to make sure the healthcare provider is going to be provided the.
Well, this is Mr. Chairman.
Yeah, go
this is
ahead.
the petition filed by the facility. Shouldn't that be served on the individual who's incarcerated instead delivered or certified? I don't know what a certified copy is to somebody in jail. So that's my one question. And then, Mr. Chairman, my other one was you talk about appointment of attorney, but shouldn't it be a guardian ad litem? Are they not acting in that capacity as opposed to they're not acting as their legal interest, they're supposed to be acting as their best interest, which is a different representation. So, Mr. Chairman, I think that the language on 74 needs to be the petitioner shall serve a copy on the petition to the person for whom treatment is sought, number one.
Right.
And then the attorney language should be guardian ad litem language, not attorney language.
Mr. Chairman. Over here in Cedarville. Mr. Chairman.
Yep.
The word attorney appears, I think, 3 or 4 times in there, so I think it probably needs to be conformed throughout the entire bill to GAL, to council.
David, do you have a fix?
Mr. Chair, Senator McDougal, so the goal is to replace every instance in the bill.
No, Senator McDougal.
I didn't maybe go as far as Senator Servell does, but I think in that section B, the court shall appoint a guardian ad litem and I think that the rest of that language is probably not needed once you say guardian ad litem, because their role is to represent their best interest.
So on line 88.
Mr. Chairman, I think it's 85 and
Yeah, but it goes down and says
88.
prisoner's attorney, so you want.
In the 85 and 88 is where I think it needs to go. And maybe Senator Servell saw it in other places. That's where I'd focused.
So replace those 2 attorneys with guardian ad litem.
It's also 94, 149 too, but.
Okay.
Mr. Chairman, he said 94, and what was the other one?
149.
That looks right.
Yeah, I agree. All right. All right, let's hear it.
All right, she's telling me that the
Eileen Longenecker with OES at the Supreme Court. This statute deals with petitioning the courts for local inmates to get permission when it's lack of consent. The statute currently that deals with prisoners in the Department of Corrections is 53.1-40.1. And I only raised the issue, I don't have a copy of that statute with me, but I've looked at it with reference to this bill. And that statute does talk about the appointment of an attorney. And so the only question I raise is if that's the comparable statute to this one that uses a lot of the same provisions, it may perhaps cause confusion and difficulty for the courts if in a very similar process, if not identical in a lot of respects, that the term, the court is appointing attorney in one case for a local inmate, but yet, if it were changed to a guardian ad litem for a local inmate, yet it's an attorney for a DOC prisoner.
Mr. Chairman?
Yes, Senator McDougal.
Eileen, doesn't a GAL have a different legal responsibility to the individual than an attorney? So they could decide that it might be in the individual's best interest to have the care given, but the attorney would have to represent their legal interest, not their best interest.
Mr. Chairman, Senator McDougal, yes, you're correct. The guardian ad litem plays a different role. I'm only pointing out that we are perhaps creating a problem if in the case of a DOC prisoner, they're appointed an attorney for the same process, whereas if we say for local inmates, we appoint a GAL for the same process. I'm just pointing out we're creating a distinction between the two statutes when the process is basically the same. And so I simply wanted to raise that issue because I think it will potentially cause confusion for the courts if the existing statute says appoint an attorney. And I don't know if someone can pull up that statute quickly, but I believe it
Mr.
says
Chairman.
appoint an attorney.
Senator Serval.
I have the statute right here. It's not quite as comprehensive as the bill we're doing, but the word attorney appears 3 times in 53.1-40.1.
Mr. Chairman?
Yeah.
Sarah Serval, is that statute just for individuals who are going to receive treatment outside of the hospital? And, Mr. Chairman, because I think this statute is, I think that DOC statute is for anybody who's incarcerated has the right to an attorney in actions that are brought against them, and that's typically civil.
The 53.140-1 has to do with prisoners incapable of giving consent who need additional treatment, I think, outside the facility.
Outside the facility.
That's what it looks like.
The distinction may be outside the facility, but it's the same court process. Lack of consent, inability to give consent to treatment. So I'm simply raising the issue that it may create an issue for the courts if it's appoint an attorney for DOC prisoners, but appoint a GAL for local inmates.
Gotcha.
Mr. Chairman, I think and maybe Sir Serval disagrees, I think maybe we made the mistake in the DOC section and that should have been GAL. But maybe we ought to leave this one as consistent and Sir Serval bring back the fix for both of them next year.
All right. All right, so Serval, you got your first bill for next year already, right? All right, any other members have a question?
Move report.
What? No, did we adopt amendments to his bill? All right, we haven't adopted the amendments to the bill, so I'll go ahead and move
Adoption
those.
of the
All right.
amendments.
Been moved and seconded to adopt the amendments. All those in favor say aye.
Aye.
All right, the bill is properly for us to report.
I move we report the bill.
All right, been moved and properly seconded to report the bill. Committee will vote. Sorry about that. I felt like we were in courts of justice for a while there.
Thank you, Mr. Chairman, appreciate it.
I don't think that Senator Serval can carry the bill next year because he didn't vote for this.
Either that or agrees with the count already.
He's being pure.
Thank you, Mr. Chairman.
Okay. All right, I'm going to do a quick cleanup real quick because I want to get tight. We have House Bill 2219 that needs to be re-referred to Education and Health. It's been moved and seconded to re-refer 2219 to Ed and Health. Committee will vote on that. Also have 2296. That needs to go to courts. It's been moved and seconded to send 2296 to courts. All those in favor, vote aye. Go ahead and vote on the board, guys. You tracking, Mary Ann? One more, Mary Ann, is 2652 that needs to be re-referred to Education and Health. It's been moved and properly seconded to do that. Okay. All right. Which one's Rusal's bill? Because we need to get that out of here. He's on the list, but I want to just get it out of here. Hold on. Okay, we're going to take up Senate Bill, or House Bill 2521, which is Delegate Rasul's bill. At his request, he's not here, but we're going to conform it to Senator Mason's bill with 2 line amendments, and I'd move the line amendments.
To make it like, Mr. Chairman?
Yeah.
I'm sorry, Carter Harrison from the Alzheimer's Association. To make it like his, it needs to stay the same.
Okay. My notes are wrong then. David, is that right?
Mr. Chair, it's 2 line amendments to make them conform.
Okay.
You want me to read them?
Yeah, go ahead.
Okay, so, Mr. Chair, the only difference between the 2 bills at this point in time is the last sentence. And as part of that, on line 19, after this, you would strike section insert act, which is the correct terminology since this is a section 1 bill. And then after shall, you would strike be construed to alter the requirements and insert apply to the provisions, which is the terminology that we use when we're attempting to stipulate that one section shall not affect another section or a specific regulation.
I remember that. Okay, we good with that? Senator Mason, you good with that? Good with that? All right, so Senator Mason makes the motion to, for the line amendments. It's been properly seconded by Senator Black. All those in favor of the line amendments, vote aye. Aye. All right, that bill is done and it's before us. All right, it's been moved and properly seconded to report House Bill 2521. Delegate Fowler.
Morning, Mr. Chairman.
Good morning, sir.
Yes, sir. House Bill 1981 is a bill that will reduce just a little bit of the bureaucracy in our state agencies. Mr. Chairman, it's an administration bill that seeks to make a change in the Virginia Correctional Enterprises Program. Currently, the state agencies are permitted to purchase goods and services outside of the program, but they must first obtain a waiver. And House Bill 1981 removes the dual approval process in favor of a single approval by the Chief Executive Officer of the Virginia Correctional Enterprises Program to review and approve the waiver. And the bill also contains notice provisions when a waiver request is denied. And, Mr. Chairman, that is essentially House Bill 1981. It's an administration bill again.
So Delegate Fowler, were they having a problem trying to get consensus between 2 people, and they're saying the chief executive should get it since he's the boss? Is that what we're trying to do?
Yeah, that's what I heard. They were having a little contest up there, so they said
Okay.
they whittled it down to 1.
Okay. Anybody have a question on this one? Anybody wish to speak to the bill in the audience?
Move the report.
All right, it's been moved and properly seconded to report the bill. Committee will vote.
Thank you, Mr. Chairman.
Yep, you're out of here. Thank you, sir. 15-0. Let's see. Took up
J. Jones said.
Where is it? Hurst bill, 1901. Okay, Delegate Hurst, 1905.
Good morning, Mr. Chairman, members of the committee. I have two bills, if it would be all right, if we could kind of take them out of sequential order and start with what might be an easier one to address first, which is House Bill 2634. And the only reason I say maybe easier is just because it is a companion to the Chairman's Bill 1110, Senate Bill 1110, which is reform for how we do mixed beverage licenses here in the Commonwealth, reverting counties to being default wet instead of being default dry.
All right, we can do that. Let's do that.
Mr. Chairman, Senator, it's already, we went ahead and took care of that over on the House side.
It's
so
done.
coming
It's
to
the
you
same.
Yes, as
Yep,
totally
let's-
conformed.
All right, been moved and seconded to report 2634. Committee vote. Okay, let's take up the other one now. 1905.
All right, thank you, Mr. Chairman, members of the committee. The other bill is House Bill 1905, which adds additional parcels to the long list of exemptions in 41-126.
Mr. Chairman, Delegate Hurst, is this close to
Sure,
the one
Mason.
we did for you and got the wrong corner last year?
Mr. Chairman, members of the committee, this is not dealing with that one. This adds 4 additional parcels in Southwest Virginia, one in Giles County that came to me as a request from a constituent who has a farm and a wedding venue operation, and she's looking to expand the business opportunity in Giles County, where they're really trying to focus on agritourism and ecotourism. The other parcels, there are 2 located in the town of Pennington Gap that are restaurants that were at the request of Chairman Kilgore in the House, and then one in the town of Clintwood, which came at the request of Delegate Moorfield, but it is technically in Delegate Pillion's district.
Mr. Chairman.
Senator Black.
So is the concern of this bill that if you went to the local people with the referendum, that they would turn that down?
Mr. Chairman, to the Senator, I don't think there's necessarily a concern. There just has, in many counties that are either dry or what we consider to be partially dry. And of course, keep in mind that no county prohibits the sale of alcohol. You can still buy beer and wine, and there are ABC stores in nearly every single county we have in the Commonwealth. I can speak specifically for the one that was brought to me by a constituent, where we talked to her about the difficulty in not only trying to get the law amended here in the General Assembly, but also the difficulty of trying to go and either have a referendum that's initiated by a citizen or by the Board of Supervisors. She tried for about a week to 10 days to see if she could go through the process of collecting enough signatures to get it on the ballot, and she just found it to be cost prohibitive for her because she's a small business owner and a farmer.
All right. Senator Black.
So basically, she has tried to initiate a referendum, and the local people have refused to support it. Isn't that the case?
Senator, Mr. Chairman, I wouldn't say that that's necessarily the case. She just didn't think that she could go through the expense and the time necessary in order to go around and collect the signatures herself. And so we said we acknowledge that and how difficult it is for people who are trying to start a small business and maintain a small business to do some type of citizen-led initiative. And so we just thought that especially considering we were also going to try and tackle reform, which is something that this committee, the ABC subcommittee, and of course the chairman has been working very diligently on. So knowing that those two things were going to be happening parallel to one another, we still thought that it was important to try and get her immediate situation addressed. And then when we introduced the bill, we had, again, delegates Kilgore and Moorfield also interested in seeing if they couldn't have their localities addressed in this legislation as well.
So it's easier to change the state law than it is to get the locality to just run a referendum.
Mr. Chairman, to the Senator, I think it would be impossible for a citizen to be able to come here and pass a law individually, and certainly the time and expense required to come to Richmond and lobby would also be difficult to do. So this is one woman who has a farm, is trying to expand her wedding venue operation into being able to have it be more profitable and more attractive. I think that she asked me to try and do her something that was for the greater good, and I think that this is what you have before you.
Got it. Senator Chafin.
Mr. Chairman, I would say, I have a comment, and I would say that these locations are all representative of economically depressed areas in which organic growth, economic organic growth is a positive thing, is a good thing to see jobs being created and to see restaurants being opened that are able to serve the public. And so I would like to support this measure.
David May, would you like to give us a little bit of the comment of why we got here? I think Delegate Hurst did a good job of explaining this, and not the first time we've heard exception bills, so.
Sure, Mr. Chair, to just enlighten the committee and remind the committee, we had a special subcommittee this summer that looked into a few issues. One of them was about the mixed beverage referendum, which the resulting bill was Senate Bill 1668, which Senator Reese has carried, and now Delegate Hurst has put one in as well, House Bill 2634, which we just reported out. So under the terms of those two bills, we would be flipping the mixed beverage referendum so that all localities would be default wet, where mixed beverages could be sold unless they opted out. One of the main goals of that was to, actually does, get rid of this entire section of code in an attempt to get rid of the Christmas tree and, obviate the need for any more exceptions to be created. So this bill, on the other hand, would create a few more exceptions to that rule. If the bill passed, they could work together. That basically what the difference would be is that these specific facilities would forever be grandfathered under the old rules and not the new system, and they would be able to get a license this summer as opposed to having to wait a year because there is a delayed enactment clause on the other bill.
Yes.
Anybody have a question about it? Okay. Anybody in the audience wish to speak to the bill? We've heard similar bills. All right. Been moved.
Before we do that, I have a question.
Senator Cosgrove.
Like I said, I asked council. Obviously, this isn't a locality. This is a piece of property. So under the rules, is this basically a a supermajority vote? If I just do the city of Chesapeake, then it requires, I guess, 80 votes. Is that correct? Two-thirds. Two-thirds, I'm sorry, yeah. Would that be the same on this?
Mr. Chair, Senator Cosgrove, I would not be the one to make that determination. I know that in the past, we have not required a supermajority determination on similar bills.
We've just flown them through.
Well, yeah, well, Mr. Chairman, if I might.
Yeah.
Certainly, a lot of things come out of committee, but basically has to be determined on the floor whether it requires a supermajority or not. So I was just curious about that. Okay. But to state, I hate these bills. I hate these little, couple of acre bills. And hopefully, what the actions we took earlier will just make these all go away. So that being said, I'm going to support your bill, but
That's the goal of the previous stuff, is to resolve that. Any other members have a question? No. All right, it's been moved and properly seconded to report the bill. All those in favor, vote aye.
Nays 13, nays 2.
13-2. Is that all you have, Delegate?
Yes, Mr. Chairman.
All right,
Thank you,
thanks for
Mr.
being
Chairman,
here
members of
today.
the committee.
All right, Delegate Collins.
$1935? Yes, sir.
Committee, bring your attention to 1935 inmate workforces.
Thank you, Mr. Chairman, ladies and gentlemen. HB 1935 is a technical fix that was brought to me by my jail superintendent. Basically, it redefines what a violent crime is. We have it already named in the statute. We have a list of all the violent felonies in Virginia, and it references that statute. The issue that was happening is, for example, breaking and entering is not considered a violent felony, but it is considered a violent felony for sentencing purposes, so jails were keeping people from going to work release based upon that. So this is a cleanup of that language to say the legislative body has already determined what are violent felonies in the Commonwealth, and these are violent felonies that will prevent you from being on work release. It is still within the discretion of the jail. This is not an automatic. It's still up to the jail, the sheriff or their designee, because the superintendent of a jail still is designated by the sheriff, the local sheriff, whether or not someone's going to be serving on work release or on HE or home electronic monitoring or such. So that's the reason there was some confusion about in the court system about what is a violent felony, what is not a violent felony. So this was brought to me for that purpose.
Mr. Chairman?
Let me go to Senator Sproul and then Senator Dustev.
So are you saying it's still up to the sheriff?
It is. So if you are incarcerated and you apply for work release through the jail, through the regional detention center, it is still up to their discretion whether or not to allow you to serve your sentence on work release. So that's the current law. I'm not changing that.
Senator Sproul.
I'm trying to understand. I understand that, but I'm trying to understand. So what part are you trying to change? Because
I understand. So.
Hold on one second. I think Senator Dustev probably can answer that.
I think I can probably help you with that.
I got another question.
Chairman, if I may.
Yeah, let him try to answer your.
Delegate Collins. So what you're doing is you're taking the violent felonies portion out. I understand that, but you're referring to 19.2.297.1, which is sentence of persons twice previously convicted of certain violent felonies. So first and second degree murder, mob-related felonies, kidnappings, malicious felonious assault, robbery, carjacking, arson.
Mm-hmm.
So you're now, I believe, the way I'm reading this, you're expanding it?
Mr. Chairman.
Hold on, Chris.
I got you.
Oh, not listed there. Sorry, as you were. It's any of those not listed there.
Oh.
So here's
So
means forget it.
But this only says anything that's not listed here as a
So all the
twice
bad stuff,
previously
you
convicted.
can't do
But
it,
can you be convicted once of any of these?
Yes.
So you can be convicted of first degree or second degree murder, maybe both, mob-related felony, kidnapping or abduction felony, malicious felony, robbery, carjacking, et cetera, et cetera. So you can be convicted of all these, but only once.
Well, Mr. Chairman, Senator Giuseppe, the idea is that if you have a conviction, if you have been convicted of a violent felony as defined in the code, then that would be a bar to your entry into the work release program, okay? As it stands now, the way the language is being read, the sentencing guidelines is a much more longer list of what we consider violent felonies. And so therefore, there is some confusion within the court system or within the superintendents is saying, well, you've been convicted of breaking and entering. I'm using that as an example. Breaking and entering is considered a violent felony for sentencing purposes, but is not a defined violent felony in the Code of Virginia. Now, if someone wanted to bring that bill, obviously that would be a different conversation. But the confusion was, what is a violent felony? And are we using the sentencing guidelines, violent felonies, or are we using what the legislators have said is a violent felony?
Mr. Chairman, just to, if I may, to answer. Okay, I was trying to answer your question.
You confused the heck out of me.
Yeah.
But so if you do that, then what about when the sheriff use those who are incarcerated in the city to help clean the ditches out, what have you? I know Sheriff in Portsmouth and in Chesapeake, they do use those. I don't know whether they distinguish whether they non-violent or what, but they use them to clean the ditches out, to cut stuff on. So if you do that,
yes.
he can't use those. So why you let them? Why you say, but it's okay for them to come behind my house to clean the ditch out, but they can't do work relief?
Mr. Chairman, Senator Sproul, that's not really what I'm saying. But the purpose of the bill is to simply define what a violent felon is. Okay, it is still within the discretion. Your jailer, okay, and back home, he says, I have a task work group that works outside the jail. I take them out. They clean the trash up in the median along the interstate. Okay, that is still within his discretion to put whoever he wants to on that crew to go out and work out in public. All right. So it's still all within their discretion to do that. What we're trying to do here is actually increase that, simplify that definition. There's some superintendents who are not sure what a violent felon is.
One second.
Hmm?
Right, so what I was trying to say is, you should bring it back to here, which Senator Easton was listed as in the code. Okay, so they're just taking.
Are you a lawyer? I am. I got to put my law. I got to help my Jay Jones and Steve Hurts, my lawyer. They got to help me out. Is that all right, Jay? I'm good. This is okay. I'm good. Thank you.
All right. Senator McPike.
Mr. Chairman, just a question for the patron. I see there's an amendment that deleted jail superintendent. Can you tell me about that? Because my locality has a jail superintendent who does not report to the sheriff.
Senator, I sit on another committee where there's a Chairman Bell. Chairman Bell apparently ran 20 years ago on the issue of appointing individuals.
In work release, that is current law. Superintendents are then designated by their sheriffs or other elected, the sheriff's in charge of actually in charge of the jail. So a superintendent does not have the authority under the code to put people on a work release. So we've used, or their designee. So the sheriff's department routinely gives letters to the superintendents of jails to say, you have the authority to put in people on a work release if you want to. I'm trusting you as a superintendent.
Okay, follow-up question, Mr. Chair.
Sure.
For Prince William County, the sheriff, again, and the superintendent are two separate entities.
Yes.
Designating, how would the pass-through, I guess, authority really work when they're not in the custody of the sheriff?
Mr. Chairman, Senator, there's a letter that your sheriff, your Prince William County sheriff has written a letter designating, authorizing the superintendent of your regional jail to have that authority pursuant to the code.
There's an MOU in Prince William with the ADC there. I know that for a fact.
My regional jail has 4 localities, 4 different sheriffs. And so my superintendent has 4 separate designations from 4 different localities.
Right.
Mr. Chairman, I like the
Senator
bill.
Favola.
I'd like to make a motion, but you may want to ask if there are any speakers.
Is there anybody against the bill? Anybody wish to speak to the bill? All right, Senator Favola has a motion, and we have a second?
I move that we report the bill.
All right, it's been moved and seconded to report the bill. Committee will vote. Okay, 14-1. Do you have another bills?
I do. I have HB 2301, which is the retail cigar shop.
Okay.
Which one is this?
This is similar to the same bill that I brought last year.
Yes.
And we did get out the Landis bill. Mine was a little bit different from Steve's. But let's hear the bill.
Mr. Chairman, as you've said, this is identical language to what passed out last year. Except for there's a line 7 change on the bill, but other than that, just so everybody knows, I'm a co-owner of a cigar shop. This would not apply to my cigar shop because we have a private club license from the ABC, so we have our own standalone ABC license. So this would not apply to my facility. And I think everybody knows that right now. I'm pretty sure everybody on this committee has heard the argument before. Right now, barbershops and nail salons can serve alcohol to their patrons. And I recognize some of the concerns that we are creating bars and speakeasies and things of that nature. And I think that's, we're only talking about 2 drinks per patron. We're not talking about selling alcohol. We're talking about providing alcohol. And I think that we have had a variety of this will help clean up some of the other things that are going on in other cigar shops around the Commonwealth who are skirting around some of the ABC rules and providing alcohol without the food. And I think that this would, be very helpful to the industry and also to bring a lot of, excuse me, get all choked up about it. That I think that this would be helpful to the industry as well as to clarify some of the ambiguity in the ABC laws when it comes to who can provide alcohol to customers, because we have made a variety of different amendments to the ABC laws throughout the years to allow, for example, a nail salon to serve wine to an individual.
So let me just interrupt, and then I'll go to Senator Cosgrove for the members. So this actually came up as part of the discussion this summer in the ABC working group, and one of the reasons why, and we've included it, should we not pass the bill, I'd like to see us pass the bill because we've made exceptions for other members of the Senate to get some of these exemptions out. We made 2 so far. But it will be part of my orders on the letter to Travis to fall under there, because this would be one of those exemptions that we've talked about. And we've heard from our restaurants associations and all the others, and so we've heard this bill beat to death. So it's really up to the committee on where we want to go. But I would tell you that we're going to work very diligently to clean these up, to have a lot less exemptions to this thing, where folks who are having these types of business can operate and open, but still be able to manage those under the ABC laws without putting an undue burden on ABC. So, Senator Cosgrove.
Thank you. Delegate, is your shop in Winchester?
It is.
It is. In full disclosure to the committee, I know his mama. Does your mama know that you're schlepping tobacco and booze in Winchester?
She's not too appreciative of my father enjoys coming over and spending a couple of nights a week I get him out of the cruise ship, the Westminster Canterbury. I get him out of the cruise ship, never leaves port. So he appreciates the.
Mr. Chairman, seriously speaking to the bill, this bill just makes sense. We have a place in Norfolk called the Town Point Club. Now, it's a restaurant, it's a meeting place, but it has a cigar facility there. It's separately ventilated, and you smell terrible when you come out of the place. But, it's really no different there. They have, Grand Marnier or fine bourbon or whatever, and cigars. This just allows, these type of shops to have that type of environment. We're not talking about, wild parties and that type of thing. This just makes good common sense, and I hope we pass the bill, and I'd move to report the bill.
Before we take up that motion, Senator Sproul, you have a...
Yeah, Mr. Chairman, I'm hearing what my friend from Chesapeake says about common sense. They have the restaurant, but I want to hear from the food place person first. Number one. Number two, when you have that 2 drinks, if it's not a restaurant with food in it, my question, who says that they're going to serve 2 drinks? I don't believe everything they say. I don't believe everything I say. So I want to know, you talk about 2 glasses. How do I know it can stop at 2 glasses? And so, but if you got a food restaurant, it's something different. So that's my concern. You're saying 2 glasses of wine, but how do you know that they're not going to sell more 2 glasses of wine to sell a cigar? I want to hear from the food place, if you don't mind.
Yeah, we can hear from them. Hey, Tom.
Mr. Chairman, members of the committee, Tom Lisk, representing the Virginia Restaurant, Lodging, and Travel Association. And we have historically opposed this bill, and we continue to do so simply because you would be creating the first essentially bar license. Only distilleries right now have the privilege of serving mixed drinks without food requirements. This would create a brand new license to allow the service of not only beer and wine, but full mixed drinks without any food requirement. There admittedly are very few places in Virginia where you can go smoke a cigar and have a cocktail, but there are restaurants that have created that environment where you have that option. There are private clubs that have created that environment where you have that option. Town Point Club, you have food there as well as alcohol. So if you can smoke the cigar, you can also get something to eat. If you pass this bill, there will not be a food option, and that creates essentially a bar license. And for that reason, we oppose it. Thank you.
Mr. Chairman, if I might.
Hold on. Senator Bosco was next.
Mr. Chairman, question for the patron. In your testimony, you discussed that you have your own store and it's a club, so you already have the allowance to do what you're asking for. Why do we need legislation then if you're able to already serve alcohol?
Mr. Chairman, Senator Boysko, the club exception for the ABC is that it has to be a standalone building, have its own lease, and it's a standalone room, and you have to get city council approval to allow to have a private club. It's a non-private private club. So not every cigar shop is able to have We renovated a house, turned one side into the retail side, turned the other side into a private club area. Additionally, so a lot of other cigar shops are more strip mall where they don't have that ability to have a separated area, and so the ABC will not give them a private club. So that's how we were able to get it done, and that's the reason. But that's also the reason why other people can't get it done.
Okay, who is next? Senator Favola.
I have a question. You made an analogy with barbershops and hair salons, et cetera, et cetera. I don't go to a barbershop, I go to a hair salon, and they only serve wine.
Mm-hmm.
So would you be amenable to an amendment that took off or mixed beverages?
The reason that I think that the reason I would not, I'm sorry, Mr. Chairman, Senator Favola, the beer and wine, I would assume that the senator probably has not enjoyed a fine cigar, but the idea is that the consumption of bourbon and port wines is one of the things that enhances the enjoyment of it, and that's the reason that we think that this would be. I think wine and beer, although I appreciate what the senator is doing, but I think that the mixed beverage is really what's going to be most helpful. So thank you.
And I'll just point out real quick, it's very detailed of what a cigar shop is. I mean, that's quite a bit of, at least 200,000 and 40% or more of its gross revenue. So we're not talking speakeasies, we're talking legitimate cigar shops to do pairings with. So it's a policy decision. We've discussed it. I see Miles in the back. You want to come on up?
Mr. Chairman, very briefly, Miles Laurie on behalf of the Downtown Business Group. I want to associate myself with Mr. Lisk's comments, but the thing I would add, you really are looking at that well-known camel under that familiar tent, because you do this now. There are going to be some folks who think that a fine haircut should go with a fine bourbon. So I think you really
I would agree.
Thank you.
Is that a motion?
No, Mr. Chairman.
Senator Cosgrove.
Thank you, Mr. Chairman. Look, the Downtown Business Club is always here, opposes every single alcohol thing that comes before this committee. I mean, just hold up a no sign. We'll know what you mean. Mr. Lisk mentioned, there would be no food option. There's always a food option. If you want to serve food, you can serve food. So to say there's not an option is just wrong. There is a difference between basically this bill and what happens in salons, et cetera. And, I was in the General Assembly when we first allowed wine at day spas, and then it's beauty parlors and barbershops, and you name it, it goes on and on. But for those who do enjoy a good cigar, it's quite an enhancement to have that little bit of alcohol. 2 drinks is not a whole lot. I hope we would pass this bill. I mean, we've got to get beyond some of the arcane rules that we have when it comes to this type of thing. So those are my comments. I think it's time for this bill to pass, Mr. Chairman.
All right.
And I move to report the bill.
All right. It's been moved, and I'll second it, that the bill will be reported committee vote. All right, nays 9, yeas 6, but that bill will still go under the umbrella as per my instructions from the working group this summer for Travis to look at for those consolidations of licenses. So we have that, Delegate Collins. So.
Thank you, sir.
Yes, sir. Delegate Foy? Foy? Is that right? Did I say it right?
Mr. Chairman?
Yeah.
Delegate Carol Foy has the same kinship bill that I had.
Okay.
Although they adjusted it on the House side, much to both of our dismay. So she's happy to conform hers to mine. They will be different, but I think that's.
I think there's one line amendment to take up on that.
But that's the problem. The line amendment. I beg your pardon.
So we need to move the line amendment.
Move the amendment.
Senator Mason moves the amendment. It's been properly seconded by Senator Cosgrove. All those in favor say aye.
Aye.
David, you want to say the line amendment?
Mr. Chair, the amendment would be on line 14 after shall strike take all reasonable steps to, and basically that amendment just kind of watered it down. Instead of requiring a local board to provide notice to relatives of their eligibility to become a kinship foster parent, it directed the board to take reasonable steps to provide notice.
Okay, so it's exactly like Senator Mason's bill at this point. So Senator Mason makes the motion to report, Senator Cosgrove seconds. All those in favor will vote aye. 15-0. Delegate Mullen. Yeah, it's on my screen. Huh? What's the last name? Jones is next. It's right here.
There's no Norfolk Mafia here.
Go ahead, sir.
Good morning, Mr. Chair. So I have House Bill 2438. This bill, well, in 2012, we decided that the Department of Department of Criminal Justice Services should be the one that would decide for the Department of Juvenile Justice what the training standards would be. Well, it turns out that kids are different, and that looking after children in Department of Juvenile Justice custody is very different from looking after children in DOC custody. And so that means that there are additional training requirements. There's a different additional oversight that comes in looking after children. And so working with the Department of Juvenile Justice as well as the Department of Criminal Justice Services, the thought is with this bill that we would move back the oversight of the training standards from the Department of Criminal Justice Services back to DJJ, where it originally belonged. So that, Mr. Chairman, is the bill.
And then it also requires minimum entry-level in-service advanced training, so the same thing just is requiring more of that training with
Exactly.
specific training requirements for juveniles.
So this is not lowering any standards when it comes to, but is in fact keeping them where they are.
All right.
DJJ
We
is
got the
also-
thumbs up from them.
Oh,
Yep.
all right.
I'm on
Well,
Juvenile
yeah.
Justice Advisory Committee. So, Senator Sproul, did you have a question? Oh, okay. All right, it's been moved and properly seconded to report the bill. All those in favor, vote aye. Ayes 15-0, thank you.
Always a pleasure seeing you.
Yes, sir. Delegate Jones.
Good morning, Mr. Chairman, members of the committee. I have House Bill 1871.
Okay.
This
This is, before you start, this is identical to Senator Favola's Bill 1145, which reported out of here 12-1 with one abstention, and it was re-referred to Finance.
And it is in the Senate budget.
And it's also in the House budget, Mr. Chairman.
It is. Okay, so we've heard the bill. Anybody have a question?
I move to report.
Okay, it's been moved and properly seconded to report the bill. No, I caught that when you went to the side.
Thank you, Mr. Chairman.
Sorry to make you wait so long, but we got a long docket today. Delegate Delaney.
Good morning, Mr. Chairman.
Good morning. This is similar to Senator Vogel's bill, 1257. It reported out of here 14-0, re-referred to Finance. There's one amendment if we want to conform it, and that's to add the clause to it to make it the same.
I believe, Mr. Chairman, I believe our bills are identical. I believe.
All right, hold on, let me check with my attorney. We're on 1659. They're not. Yeah, we got to put the clause on there. Are you familiar with the clause, Delegate?
I'm vaguely familiar.
Yeah, well,
It's a finance clause.
we're going to have to put the clause on it. So the motion would be to amend, to add the clause, to conform the two bills, and I would so move. It's been properly seconded to conform, adding the clause. If you all need to hear the clause, David can read it. Anybody? You want to read it? You want to read it so the delegate will understand what that means on the Senate side?
$12.57. Senate bill, companion bill.
The clause would read, which would be at the very end of the bill, after line 109, that the provisions of this act shall not become effective unless an appropriation effectuating the purposes of this act is included in a general appropriation act passed in 2019 by the General Assembly that becomes law.
So you have a budget amendment in,
This has been through House Appropriations.
and is it in their budget?
Mr. Chairman, I mean, it passed through appropriations and through the House. So-
Okay,
I'm
all
not
right.
sure it is.
Okay, all right. So it's been moved and seconded by Senator Cosgrove to add the clause to it. All those in favor say aye.
Aye.
All right, that's done. The bill's properly before us.
The report is
Second.
All right, it's been moved and seconded to report the amended bill and re-refer to finance. All those in favor, vote on the board.
This didn't go to finance, Mr. Chairman, I don't think.
It still has to go.
Okay.
Yeah, all revenue bills have to go.
No.
No, but this is my first bill, Mr. Chairman, Senator, in this posture. So that's some of my confusion for the clause and then
So.
that aspect
so,
of it.
If I can just tell you, you get with Senator Favola or one of the other members in the Senate, and we can tell you how to kind of navigate some of this stuff.
I
So it's one
appreciate
thing to get a bill passed, another thing to get it in the budget, so.
Appreciate it, Mr. Chairman.
Yep, no problem. Is that your only bill?
No, Mr. Chairman, I also
Okay.
have House Bill 1819.
All right, 1819. Where's that one? Not missing it. That's just, all right. All right, child support enforcement fees. Go ahead, Delegate.
So, Mr. Chairman and members of the committee, this is simply a agency conformity bill. We need to conform our child support collection fee to the federal language and new adjustments, new structure. And this is tied to our TANF funding, so that's why this is a necessary adjustment to make conformity adjustment to ensure that we don't lose our TANF funding.
Delegate, real quick, why did they move it from 500 to 550, do you know?
Mr. Chairman, I don't know the exact reason why the federal government made that adjustment. I know this is the costs that are applied towards collecting and distributing child support payments, and so the federal government made the decision to make these adjustments. So this is an agency bill where they're asked me to carry this since we do
To
need
get in line.
to conform.
I got it. We do a lot of that in here. Senator Mason took up the Family Care Act, and we had to do a lot of that. Do any members have a question for her? What she's doing?
Mr. Chairman, is there a financial impact on this bill?
No, this is just,
There is, but it's a wash.
yeah. Senator Black?
Mr. Chairman, so what we're doing, as I understand, is for example, the wife whose husband is paying child support, she's going to have to pay an additional $10 each time that social services assists her with the collection effort?
So, Mr. Chairman, Senator, unfortunately, that is the way that this is structured in Virginia, and I know many of us had conversations about the fact that that is how we do it in Virginia, and express some disappointment that it is done that way, because it is essentially being removed from the pot of money that would be going to that custodial parent. And I know many of us agree that that may not be the most optimal way that the fees are collected, but the other side of that story that I was told was that that's really the only way that the agency can ensure that they get the funds that are required to deliver the service that they're delivering of obtaining and providing the funds. And so they are providing that service. I agree with you, Senator, that it's not optimal, in my opinion, as to how we're doing it, but I also understand the complexities of restructuring that. It would probably be a much heavier lift, and this bill is strictly a conformity bill that does help us protect our, okay, someone who can probably answer better than me.
Just one question, and perhaps he could fill it in. So is this a totally self-funded program?
Good morning, Mr. Chair and Senator. My name is Ron Harrison with Child Support Enforcement, Department of Social Services. Just a slight correction to your earlier question. This is not a per collection charge. This is a one-time fee. It's only done annually. So, and that's only with the child support collection exceeds the threshold of $550. So it's only collected one time per year.
And one
Senator Black, go
follow-up.
ahead.
Okay, so where does that money go? What is the purpose of that fee?
Well, the whole purpose, this is as a result of the Federal Bipartisan Budget Act of 2018. This is to fund the approximate collection based on our 2017 collection was approximately $800,000. So we are required to refund to the federal government 66%. So the Commonwealth of Virginia will retain approximately $200,000. So that's used to help fund the program, the child support program itself.
Okay, so it is self-funding to that extent, is that?
Yes, sir, it is.
Okay, thank you.
You good? Okay. Anyone else? All right, entertain a motion. It's been moved and seconded to report the Senate Bill 1819. All those in favor, vote the board.
Thank you, Mr. Chairman and members.
Yep, you're good.
Thank you.
Delegate Heretic.
Good morning, Mr. Chairman, Senators. House Bill 2213 basically and simply adds local probation officers and pretrial service officers to the list of those court authorities who are authorized to receive and exchange physical or medical and mental health records concerning individuals who are in charge of their custody. This comes at the request of our local community criminal justice board after they've run into some problems in getting timely and accurate and full information regarding some of the individuals that they have to supervise in the course of their process. Simple as that.
Okay, any members have a question
Mr. Chairman.
to the bill? Senator Cosgrove.
Delegate Heretic,
Yes,
is this brought by the regional jail, the local jail?
It's actually, the suggestion, Senator, comes from the Community Criminal Justice Board in Portsmouth, which has oversight authority and responsibilities for the Hampton Roads Regional Jail. And I frankly think that this is part of the problems that they've begun to identify in the recent death of Jamichael Mitchell.
Yeah.
So, Delegate, so a pretrial service officer is going to help eliminate that?
Mr. Chairman, the idea is that the pretrial service officers typically have sometimes a very limited amount of time once an individual is arrested and is facing arraignment for the court to make a bail or release determination, and if so, with conditions. This allows pretrial service officers to provide a little bit more timely and accurate information to the court in making those decisions.
Okay, I got it. I'm tracking. Anybody else have a question?
Read the report.
All right. Servo, you okay with it?
I don't know.
Okay. All right. All right.
Mr. Chairman, can I just comment for a second? Speaking of the bill?
Yeah.
I mean, the one thing bouncing around in my head is that giving out somebody's medical records pre-trial could create issues when somebody hasn't been adjudicated yet. And so I'm not familiar enough with what a pretrial services officer does, but if I were the person, I might not want them to have it until my case is over. So I'm just noodling around in my head. That's why I seriously say I
think it
don't
still
know.
falls under that confidentiality on pretrial when they start to put all that paperwork together to go to court. So I think they would be under the same, am I not correct? They'd be
Yes,
under
sir,
the
it
same.
does, Mr. Chairman.
So, okay. All right. So it's been moved and properly seconded to report the bill. Committee will vote.
Thank you,
15-0,
Senator.
you're out of here.
Sir.
Delegate Peace. Sorry. Don't have you on my queue. I'm
I think
sorry.
it was number 4, but save the best for last, Mr. Chairman.
It's fine with me.
So this bill is nearly identical to a bill that you heard Senator Barker, 1286, dealing with auxiliary grant reforms and trying to streamline the ability for those with the auxiliary grant to access supportive housing. Senator Barker's bill had an increase in the cap to 120. The advocacy organizations, NAMI and others, would prefer that we keep the 60 number, which is in my bill, because the Appropriations Act.
So you don't want to conform to Barker's
I
bill?
would, yes, that's correct,
Okay.
Mr. Chairman. And then in the House side, he's going to go back to 60. And that would keep us in line with what is existing in the Appropriations Act.
So I know there's some technical changes and on that, you're going to fix it on your side?
We're going to fix Senator Barker's to the lower the 60 and get it in proper posture. I don't think we would want to make any changes to mine.
Have you talked to Barker?
Yes, and
Okay.
the
All
advocacy
right.
organizations have also as well, so.
All right. So we're not going to conform, we're going to let it go out.
Peace in the valley, if you will, just have to make a few little notations.
Are we doing the rest of?
No, we're going to let them work it out. They can hash it out. All right. So came out of here 15-0, Senator Barker's bill.
Mr.
So I
Chairman?
took a motion. Yes, sir.
This was a question, there's someone standing in the back, I want to know. is he for or against it?
Alexander is here to represent NAMI, if you would like to ask questions or hear.
No, I just want to make sure he's okay with it.
All right. It's been moved and properly seconded by Senator Sproul to report the bill. Committee vote. All right, Senator Peace, you have the.
Is that a promotion?
All right, excuse me.
That's right.
All right, well, now I got to kill your bill. No, I'm kidding. House Bill 2014.
I believe you already acted on that,
Did we do
Senator
that?
Mason
Okay.
handled that
I think
earlier.
that's it, then you're
Yes,
done,
sir.
right?
Thank you. Appreciate
Okay.
it.
Committee's not done yet, though. We've got a couple more bills we just got to go through. The patrons aren't here, but we're going to conform the bills, if I'm right. I think we have HB 1642. We took care of that, didn't we? All right, let me- All right, we're going to take up 1917 and 1918. House Bill 1917 came out of here. It's similar to 1273, which reported out of here 14-0 Senator Lucas' bill. We're going to conform Stolly's bill to that bill. The difference is McDougal's amendment on independent contractors, if you all remember that discussion. So, all right. The motion is to conform. All those in favor say aye. Any opposed? It's been moved and seconded that the bill be reported. Committee will vote. House Bill 1918, similar, Delegate Stolle asked to agree to conform. And I think David has a substitute for that, so we need to take up the substitute. So I'd move the substitute. It's been moved and seconded to the substitute. All those in favor say aye. Any opposed? That's before us. We have a motion to conform the bill. It's been seconded. All those in favor to conform say aye. All right, bill's properly before us. It's been moved and seconded. The committee will vote. Oh. Sorry. What do we have left? Did we do Knight's bill? 2560. All right, Delegate Pillion's bill. Okay. We're not, it's the same as Senator Chafin's bill, or similar, excuse me, to Chafin's bill. We reported out of here 15-0, but they don't want to conform it. There's an agreement between the patrons on that bill, so I think they're going to figure that out. So I'd make a motion to report. It's been properly seconded to report the bill. Yeah. $15-0. Yeah. What we got left? That it? They've just passed out, just for the committee's information. If you can get back to Mark in my office, the chairman would like to take you all to dinner again this year, a little bit probably closer into town. And let me just say thank you. We did a lot of work today. Senator Cosgrove will have a subcommittee. I think he's taking up 9 bills from the subcommittee. And so we will have one last meeting date, but I don't know if it'll be like a 10 or 15-minute meeting just to go through the sub stuff, because Senator McDougal's going to need that for rules, as we always get compressed. But thank you all for all the hard work today and getting through it and the teamwork over the summer. And with that, the committee will rise.